Fantastic. Welcome back, everybody. I hope you are all refreshed and managed to meet some new people and have some interesting conversations. We will move to our second panel now, which is on transparency and development finance. Can we achieve better results? And clearly, a lot of the topics that we touched upon in the first panel we can develop further here. I will introduce our panel. First of all, Gina Barbieri, who's to my left, is the Compliance Advisor Ombudsman for the International Finance Corporation and Multilateral Investment Guarantee Agency of the World Bank Group. She's a practicing lawyer who is now specialising in conflict resolution. She co-founded the African Initiative for Mediation, is a steering committee member of the African Mediation Association. To the far left is Isabel Lavandez, who is project ombudsperson at the Independent Consultation and Investigation Mechanism of the Inter-American Development Bank. She is a Bolivian national who served at the World Bank for 12 years, specialising in land administration, natural resources management and rural development. And again, the NGO side we have on our right, is Jana Mittermeier, who is Director of Transparency International's EU Liaison Office here in Brussels. She's been with TI since 2006, and before that was the German Federal Foreign Office. And on the far right is Anis Berthier, who is a staff lawyer at the Brussels office of Client Earth, a group of activist lawyers committed to securing a healthy planet. She specialises in the implementation and enforcement of EU environmental law. And if I could start with Gina again, that would be fantastic.
Thanks. Thank you, Alex. Good morning to everybody. And in my home language of Zulu, I would say Sanbonani. So for those interpreters out there who aren't able to interpret that, that means hello in Zulu. My colleague Elf earlier spoke about the inspection panel, and essentially the CAO, the Compliance Advisor Ombudsman's Office, is the counterpart for the private sector lending arm of the World Bank Group. Our structure is really substantially different to that of the inspection panel, and we operate in a very different development frame because we're dealing with the private sector and the private sector's interface with communities through those projects. Our mandate is around social and environmental concerns. Our mechanism is triggered by communities who believe that a project in which the IFC has invested has caused harm, either environmentally or socially, or has the potential to cause harm. They can access our office with a complaint in that regard. We report directly to the president of the bank group, and we believe that that secures to some extent our independence from the institution. We don't report to the management of the World Bank Group at all, although we do keep them informed through a series of annual engagements. As I said, the CAO works at the intersection of corporate and community conflict. And just very quickly to give you an overview of how we work, because I'll go on to the transparency in the development arena in a moment, but I think my comments need to be contextualized within the frame that we work. And that is on the basis of 3 pillars. When we receive a complaint, we do an assessment of the complaint to determine the underlying issues and interests that the parties are raising, the community is raising. We believe strongly in the community's right to be heard. So we will always go to the field to engage with the community about the issues in the complaint. And through that process, we will work with the parties to make sure that they fully understand the difference in our roles and are able to make an informed choice of whether they want to try dispute resolution, which falls under our ombuds function, or a more compliance approach. So if they elect dispute resolution, we will attempt to resolve the issues, and we most often have an engagement between the community and the company. If that doesn't work and we have unresolved issues, they can still access the compliance function. We also have the ability to advise the institution on systemic issues that we might see emerging from our case work. We don't give project-specific advice because, for obvious reasons, that could lead to a conflict of interest. Just a point on how we close the loop in terms of complaints. We also have a monitoring function, and that monitoring function applies to both agreements reached in the ombuds process as well as to the uptake of findings in compliance audits that might be generated through the compliance arm. The other thing I want to raise is that we don't believe that dispute resolution should become a smokescreen to holding the institution accountable where the institution has made mistakes. So we're not in the business of preventing communities' rights of access to the compliance function. We often see that the issues raised in the complaint can be best addressed through a dispute resolution process. And what's really useful for us is to have access to the three functions. Just to give you a taste of the extent to which we operate, we've had over 100 complaints essentially since inception around 2000. We've operated in 35 different countries in responding to these complaints. I would say we're looking at about a 50-50 percentage break in the complaints that go to dispute resolution and those that go to compliance. We thought it might be quite interesting just to give you an overview of the issues that we're seeing being raised in the complaints. And almost 70% of the issues relate to consultation and disclosure, which feeds directly into the topic about which we're gathering to discuss today around transparency. In the interest of transparency, I would also like to raise a deep concern we have on issues relating to land and the big investment in agribusiness, particularly in sub-Saharan Africa, that's taking place currently. We're currently engaged in a large-scale dispute in Uganda around land, around alleged evictions of over 22,000 community members. And this, we believe, is going to be a growing pattern and has been over the last 2 years. To lead into a closer look at transparency and how it relates to the institution, I'm mindful of the 7-minute curfew. I'm generally an obedient person, so I'm going to try and rush through the rest of this. But I think it's important to understand the mission of the institution as a development institution aimed at reducing poverty and improving people's lives. And I think that that's incredibly important. And I must say, it's not very easy to find this mission statement on the IFC's website. You should go and see if you can. And bearing that in mind, some of the issues I would like to raise, and I think I'm going to raise more questions than answers, but I think this is a really healthy forum to have these debates. We're really concerned around the extent to which there is upfront disclosure of investments and the intended development impacts that the institution envisages, and the extent to which there is consultation with affected communities about what those development impacts should look like. Financial markets was raised by the NGO and I think it was the Access to Information, Access to Info in the earlier session. And that is an incredibly opaque area, not only for us to be measuring what is the development impact, but for us as an accountability mechanism to be able to ascertain, is the institution complying with its performance standards? And so we, fortunately, have the ability for our Vice President to trigger audits and compliance appraisals. And in fact, we've done that in the financial sector. Almost 50%, over 40 to 50% of the IFC's portfolio currently is in financial markets. That's really big. And so we as an office have instituted a compliance appraisal of 188 projects that the IFC has invested in to determine what does this terrain look like for us, not only in terms of accountability, but in the institution being able to measure its development impact. So that's something that we hope is going to be released toward the end of November. We're also concerned about the affected community's rights of access to independent accountability mechanisms and the disclosures the institutions are making in that regard. How many communities prospectively impacted by IFC projects know about their rights of recourse to the CAO in this instance? And then the institutional approach to risk management. Often the debate is had around credit risk as opposed to risk of harm. And we would like to see a broadening of the conversation around shared value In other words, should we not be considering the impact of the project on the communities as partners in the project rather than as a factor of risk to be managed? Just more particularly through the lens of the accountability mechanism. As a CAO, we try and adopt a transparent approach to the way we engage with complaints. There's always room for improvement. We welcome open dialogue with civil society and private sector in this regard. In our problem solving, we look for broad-based community participation. We look for the establishment essentially of ongoing relationships for information sharing, and we focus on remedy coupled with rigorous compliance oversight. We're also really keen on exploring ways of growing the extent to which we're able to feed our findings and lessons learned back into the institution. And really some questions for all of us, and some questions that I think we need to be thinking about really closely. How do we improve communities' rights of access to the IAMs? How do we institutionalize mechanisms for community consultation in the early stages of project design and the setting of development goals? How do we encourage the institutions to see us as part of their good governance structures rather than something to be worried about as an adversary to the institution? And how do we equip the financial institutions with tools to engage openly when things go wrong and establish systems for early risk detection and engagement? Thank you.
Thank you, Gina. I thought that was very, very clear and interesting. It really sets up the discussion well. Isabel.
Good morning, everyone. First of all, I would like to thank very much our host, the Ombudsman Diamandouros, for his kind invitation and for giving us the opportunity to finally get this reality check and have the opportunity to be with you this morning. I would also like to introduce to you the panel chairperson of the compliance review panel of the Inter-American Development Bank, Mr. Werner Kiene, here, join me. What we tried to do in preparing for this presentation was very much focusing on the topic of today's right to know the theme. And although I will give you a little bit of context about my institution, I will pretty much like to talk about transparency and what this transparency means in our day-to-day work, especially in the Latin American context. We are a very young baby in the arena of independent accountability mechanisms. We were created as per the governor's mandate in IDB, and we became effective only in September 2010. So it's actually our second anniversary. During this initial stage, our mechanism deals with only 6 operational policies, mainly more or less like the CEO. Those policies are around social and environmental issues, plus 2 very interesting policies, that are not social or environmental, but they are specifically important for us, the gender policy and the natural disasters policy. What we try to do our governors and our board of directors, from whom we depend directly, we don't depend from the president of the bank or management, just to the board of directors, design a mechanism with 2 arms. The first one called consultation phase, which is led by the ombudsperson, and the second, of course, the compliance review part of the mechanism. We work together under the same umbrella, although with very distinct functions. The request that any group or community or individual may submit to the mechanism first gets into our intake door, and the policy establishes a sequence that we have to follow. The request comes first to the project ombudsperson, and then if there are remaining compliance issues, or if the communities or individuals desire so, that will go to the compliance review phase. What I wanted to do today was precisely to speak about access to information, transparency, the right to know, and what is that causing, or how is that helping, in this case, the ICIM, the Independent Consultation and Investigation Mechanism, but also how is this going to impact the way in which, in this case, the Inter-American Development Bank, but also other banks work. We know all of this. We have principles and rights that, of course, are the foundation for everything we do in terms of transparency. And I wanted to highlight here a very important element of transparency, which is precisely the accountability. We all know what those principles are, but just to refresh our memory, we know that the access to information is a human right, and something that goes beyond that is that we all have the right to be informed. For the Aarhus Convention, but also in general terms in the development context, we believe that it's not sufficient to have the right to access to information and participation and justice. They are very necessary, but maybe not enough to actually make a difference. And for that, we think that a good and functional administration is also essential. So access to information, participation, access to remedies, good administration, all of that, in our view, will contribute to more sustainable and more inclusive development outcomes. We know the benefits that are associated with that, but particular attention, I was trying, when preparing for this presentation, I was trying to place on the benefit of resource allocation, how resources are allocated within the projects that these international institutions fund, but also how resources are allocated within the government's strategies and programs. We know more or less how it works, but just to give you a graphic vision of where the financing flow goes and where it overlaps with access to information, with transparency, and of course with accountability. We know that usually the borrower is a government, but more and more, especially in the Latin American context, and I'm sure in the African context as well, the private sector is now a big player, and of course typical works and investments that were done through the public sector for centuries now are done through the private sector. So the borrower can be private or public, and depending who the borrower is, the access to information, as we know, varies. One of the IDB has the access of information policy approved just last year, but one of the biggest exceptions relates to access to information to private sector documentation and activities. So many times, despite the very good will and all the capacity and intelligence of our development practitioners, since development itself is not an exact science, unexpected results may occur, and of course civil society, communities, beneficiaries of projects get impacted. So there's where we think that's the reason for our existence, and that's how we link the full circle of accountability, access to information, and transparency. We vary in terms, IMs have different rules, different policies, and different setups, but we have a common denominator, which I wanted to highlight here, and we think that by increasing accountability, we will contribute to increased transparency, and of course, by doing so, increasing the effectiveness of development operations. I just got some examples of our first 2 years where more transparency contributed, for example, to enhancing communication among communities, to clarification of issues, etc., but also, more importantly, to help rebuild trust, which is usually lost by the time it gets to a mechanism we already know there is a problem. There was a breakage on the trust somewhere. Enhanced accountability, of course, maybe goes without saying, enhances participation itself. And all of that, in our 2 years, we've seen that enables project implementation, enables a better execution of the programs and the projects. Is not very far from what people used to think, is not a barrier or obstacle. Consultation and participation, as it happens in our experience, is actually very positive for projects to be expedited. So all of that, as CEO, we also have the advisory function. We hope that we can retrofit back to the institutions so the next generation of projects will be better. The next development finance will be more productive and better targeted. Let me give you very few slides on what has happened in Latin America in this area of access to information. I'm sure you all know that there has been a lot of progress in the access to information, the legal recognition of rights. Many countries have approved different legislations. You know that the Declaration of Rio, the future we want, has a specific language, both in terms of strengthening access to information, but also strengthening access to accountability mechanisms. There were 10 countries that signed a declaration that commit themselves to move towards a regional convention, just in the same line as the Aarhus Convention. I think that is very important a step forward, and that will impact also the way not only this bank but many IFIs in Latin America work. So they have a concrete action plan, and we hope to see what's going on in the next months. There are many more news from Latin America. As you know, many countries approved access to information and freedom of information laws. There are progressive regulations in terms of public participation, in not only in environmental impact assessments, but also in consultation when programs are designed. The court systems are more open than, let's say, 10 years ago. And countries are establishing redress mechanisms, and also ombuds functions are well recognized and getting more established in our countries. But there are still some challenges for the region. As you know, not all our accountability systems, and this includes, of course, government and non-government accountability systems, are strong enough. The issue of the fading away of international finance, or what we call the mixed syndrome, not most, but a larger number of countries in Latin America now are middle income or middle upper income countries, and therefore international finance is diminishing. It's been shifted to other regions in the world, and with that also the push for accountability is fading away. And we may say everything about international financial institutions, but there's one thing that I've been hearing from communities, from NGOs across the continent saying, you know, it's better when you are around, meaning the banks, because at least you have the safeguards, and since governments are interested in this funding, they may listen to you because national laws are, let's say, in some countries usually not very well followed. And of course, there's an issue in Latin America, and it's true maybe for many other continents, with access infrastructure. What I call the access infrastructure, meaning it's not enough only to have the right to access to information, but the infrastructure is really not there, especially in these days that everything is internet-based and so on. And of course, more with enhancing legitimacy and so on. This is my last slide, I think. So how can we achieve better results? This was the key of this session. At the international and regional framework, I think I gave you a flavor about maybe the issue of the proposed regional convention will give us good surprises, and it's very positive. The other thing is at the IM's level, at the mechanism level. Sorry, I think that I didn't put it right. Let me see here. Probably. Okay. More coordinated actions. We've been spending 3 days in Luxembourg talking to each other, and I think we made a lot of progress in trying to find common ground across the mechanism, especially now that there are many more projects that are co-financed. Therefore, the need for coordinated actions across mechanisms is greater. We have, I think, made a big step forward in terms of working upstream. We don't think that just the complaint is how we handle complaints is sufficient. I think that we have a role in retrofitting lessons learned to the institution, and therefore enhancing this preventive dimension of conflicts and harm. We have to set some indicators for ourselves. I think that we have to learn how to measure our own successes or failures, and we've done very little about it. And I try to talk always about the accountability of the accountability. And finally, just at the project level, if I get to that slide, okay. In order to achieve better results, maybe the one big issue here, and I'll let you read in the slide, is how much can we do and how can IMs contribute to a greater empowerment of the people? Access to information is one thing. Having access to remedies is another. But I think that as everything in life is a two-way street, we need also the participation from civil society, more informed participation, and the push from civil society towards the international institutions so we can work together and you can see us as partners and allies rather than just a part of the structure of this international institution. I'll stop there. Thank you.
Thank you very much. And, thank you very much. I thought the point you made about how the flows of finance, or the changes in the flows of finance, are also changing the levels of accountability people can expect. It was very interesting. Jana.
Thank you very much for having invited us today to this very important debate. Transparency International is a global anti-corruption NGO, and of course we see the developments and also the creation of all these accountability mechanisms around the world, and we appreciate it as a very important process. However, we also see that there are some things that can be further improved and enhanced, and please consider these points that I will raise now not as a criticism of the mechanism as a whole, however, as some sort of incentives to further improve these mechanisms. From our very particular perspective, namely the perspective of an anti-corruption NGOs, we are wondering if the people who work in these accountability mechanisms actually have a particular eye on those complaints that also relate to corruption, because we have the impression that the scale of the corruption problem among those complaints is not visible enough yet. I'm quoting, for example, also the World Bank, who said in 2007 that our understanding of corruption is only the tip of the iceberg. So one encouragement could be to have a special focus also on fraud and corruption cases, and to review your own capacities to really understand the mechanism and so forth. When we see what the areas are that are most prone to corruption risks, that we can only point to public procurement mechanisms, and to the point when basically when a project is planned or designed, because that's the moment when the financial commitments are made, and that's also the moment when most of the sort of bribery or fraud or collusion or also in the public procurement area, kickbacks are paid or bids are manipulated, and this is also where the mechanisms have to pay a special focus or pay special attention to. Transparency International further welcomes that the different accountability mechanisms have started to engage in a more harmonized and coordinated approach, which is really necessary to exchange best practice and to see where things can be done together or where they can learn from each other. So, for example, in 2006, the task force was formed on anti-corruption issues among those international financial institutions. That also includes the World Bank and the European Investment Bank. So this is much appreciated. However, when it comes to sort of the sanctions or a coordinated approach to sanctions, here we see that a lot more could be done. And I give you now one example, and that is called cross-debarment, which we find a very useful tool to counter corruption. Cross-debarment is basically a tool whereby beneficiaries that have been found guilty of corruption or fraud are debarred collectively and across the different banks, so that they are actually banned for a certain period of time or for good to have access again to funding from the bank. And here, for example, we also encourage the European Investment Bank to join this cross-debarment mechanism that already includes the World Bank and other banks. Another recommendation that we have is, again, comes back to access to information. Here we feel that, again, a lot more could be done, that citizens have access to information from the banks. And it's not really the citizens that have to try to find this information. It's more on the side of the banks that have to go out to the citizens and reach out to them and encourage more complaints and give them information without having to ask for it. And the last recommendation that we have is related to the fact that some cases are not pursued because they fall through the cracks. We have one case that's called the Alstrom case. It's basically a case whereby a firm has not been prosecuted in a country where the group or the firm is founded, in France, because the case involved subsidiaries in Zambia in 2012. And those officials involved in Zambia are not prosecuted to date. So there was no punishment, so to speak, because the case involved subsidiaries in a developing country. And it's only to show that some cases still slip through the cracks, which should not happen. And a last encouragement before I stop is to remind the banks to think about the complainants and especially on the whistleblowers that come from within, and to properly protect those people, because it takes a lot of courage to step up and to put forward a complaint. It should not be those people who suffer in the end. Thank you very much.
Thank you very much, Anna, and thanks for keeping it to time as well. Anis.
Thank you. First of all, thank you for inviting me today. In Client Earth, we only focus on the activities of the EIB and from the angle of transparency, so I will focus on this during my presentation. Okay. So I'd like to start by, I think, mentioning something important that maybe distinguishes the EIB from the other IFIs, is that the EIB is a bank but also an EU body. So the significant consequences of this status is that the EIB is subject to EU law and also some international conventions that are ratified by the EU. And among these international conventions, there is, of course, the Aarhus Convention, which provides the public with the right to have access to information, to participate in the decision-making process, to have access to justice in environmental matters. So the EIB is subject to this convention. So even if there are some progress that have been made for the last 10 years, However, there is still a lot of resistance and reluctance within the EIB to comply with the relevant laws on access to information. So not only according to us, and not only to us, the EIB should comply with the Aarhus Convention, but also with the EU regulation on access to documents, the regulation 1049. And it's too bad that Mr. Cashman is not there anymore, since he's the rapporteur in the recast of the regulation. And the reluctance within the bank to comply with these access information laws is evidenced by the fact that there is even a new provision from the Lisbon Treaty that was added now in the Treaty on the Functioning of the EU that provides that the regulation on access to documents only applies to the EIB when it exercises its administrative tasks. So it's clear that the aim of this provision is clearly to limit, to restrict the scope of the applicability of this regulation on access to documents for the EIB. Interestingly, and even in a funny way, nobody really knows what administrative task means, I think not even the EIB. And so it's still a notion to be defined by the court. The court is the competent institution to have the final interpretation of the provision of the treaty. So one day there will be a case, we hope, to have an interpretation of this provision. And but I think that we can say I've consulted different lawyers, even within the Office of the Ombudsman, but I won't give any name, and that some of the lawyers already interpret this provision as that we can say that according to settled case law of the court, anyway, the distinction between the different functions of the institutions is whether they carry out judicial, legislative, or administrative function. Therefore, because the EIB does not carry out any judicial or any legislative function, most of its lending activities is administrative anyway, so this provision doesn't change much. And we consider that the regulation on access to documents applies to the EIB, to most of its lending activities anyway. So the recommendation today is start complying with the regulation. Compliance by the EIB with the Aarhus Convention and with the regulation on access to documents would bring concrete improvements. Some examples would be, for example, a public register of documents, more active dissemination of information, environmental information, but not only. For example, the monitoring reports, whether it is the reports of the bank or the monitoring reports carried out by external consultants and provided to the bank by the promoter. We still don't have access to these reports sometimes. Yet, under the Aarhus regulation, these reports should be actively disseminated in the register. That should be public. The environmental and social assessments of the project carried out, financed by the bank, should not only be disclosed once the project is approved, as it is the case today, but before. And the fact that the bank still refuses to disclose this assessment before the project is approved clearly shows the reluctance that there is to act transparently and to have any public scrutiny on its decision-making process. Also, the exchange between the bank and the promoter should be more transparent. We have been invited to comment on the stakeholder engagement guidelines the bank is drafting and has been drafting for a moment now. And the EIB ensures that it requires sometimes, when it's necessary, from the promoter to improve the public participation process on the ground, to consult more people or about some things that the promoter hadn't thought of. Yet, we don't have access to the evidence, to the documents that evidence this. And we are supposed to rely only on the good words of the bank, which is clearly impossible. As for any European institutions, you have to have evidence of what you say. And also, it would be a win-win situation, because if the EIB disclosed these documents showing that the bank is pushing the promoter to improve public participation, to act more transparently, it would also improve the image of the EIB. So it would be a win-win situation. Also, most of the time when the information are withheld by the EIB, it's through the use of the exception to the right of access to protect commercial interests of the promoters. Yet, For this exception to apply according to the Aarhus Convention, the commercial interest must be legitimate. It must be a legitimate economic interest protected by law. So information cannot be withheld just to protect the reputation of a company or just because disclosing information could possibly undermine the image of the promoter. Yet it is still the case. So unfortunately, as it has been said today several times, transparency is only seen as a burden and not as an improvement and not as a way to work on a day-to-day basis. And the balance, of course, is almost more often on the side of the commercial and financial interest of the promoter and not enough on the side of the environment that is being impacted by the project finance we all live in. Lastly, but really importantly, being subject to the Aarhus Convention and to the Regulation 1049 means that all the decisions to refuse access can be challenged before the courts, the European courts. Of course, the transparency policy of the bank provides for a different procedure. Yet, without any justification, the EIB is an EU body as any other EU body, as ECHA, the European Chemical Agency, EFSA, or as any other European institutions that we can challenge their decisions. We can go to court. Anyone who is refused access can go to court against an institution. That's the only situation where we have automatic standing. I guess that's one of the reasons also why the EIB drags its feet so badly to comply and to be subject to Regulation 1049. So to conclude, given the crisis in plural that we are living today, economic and financial, political and social, I think it's clear that more transparency, more accountability is needed within IFIs. And so instead of trying to withdraw itself, the EIB, a whole EU body, from the applicability of the access to environmental, or not only environmental, access to information law, and adding to the democratic deficit that there is already within IFIs, I think it's important that the banks start to comply with this text and to accept fully its status as an EU body and not only as a bank. And also another recommendation is I think that there is within the NGO community and within the other European institutions a lack of awareness about the activities of the IFIs and a lack of monitoring of these activities. Very few NGOs follow the activities of the IFIs. Compared to the impact that the projects that are financed by the bank, it's really ridiculous. So maybe more mobilization, more concern, and more funding for the NGOs on this subject would be an improvement as well. Thank you.
Thank you very much. And as a journalist, I come across these legal exemptions regularly, and not just at the EIB. But I will ask Phyllis Mina to perhaps give a bit of response to some of the points you made.
Okay. First of all, I'll start with compliance with Aarhus and all the disclosure part, and then I'll come to the fraud and corruption issues. I will say that as a complaints mechanism, we'll subscribe to most of the recommendations that you made and you are making to the bank. Having been in charge of the establishment and consultation of the bank transparency policy by that time, I can say that it was a big cultural change in the bank. Because at least on paper, the transparency policy tries to be compliant with the regulation and with the 1049. Now the problem is the interpretation and implementation. But as I said, this is part of the cultural change that takes time. And I hope that gradually we are changing the culture of the bank and bank services to be more compliant than it used to be. Now, we have a few cases that have been brought to us, to the complaints mechanism, about non-disclosure, about non-compliance with Aarhus Convention. And in most of the cases, we have been recommended to disclose the information. And we have cases, we have recommended the management committee to disclose information owned by the project promoter against the will of the project promoter. And the first time I can tell you that was really difficult, but the management committee accepted the recommendation and disclose it. And then we have, we need to move forward, but we need to have our partners moving forward, because we had cases where we owned documents that we possessed documents that were owned by other financial institutions, some of them international financial institutions, some of them bilateral financial institutions from the EU. And some of those institutions consider the different obligations in terms of disclosure, and they are not obliged to comply with ours. And then we find ourselves, the bank itself, in a difficult position to force disclosure of documents owned by partner institutions. So this is something that, okay, we need to move forward, but other IFIs and other bilaterals need also to move forward at the same time, otherwise it will be difficult. Coming to the issue of the administrative tasks, we are very much aware of the interpretation, and our internal interpretation by our lawyers is a little bit different from DIB legal services, and is more in line with the interpretation of the European Ombudsman lawyers. But okay, only the cases that will be brought forward to us will show what will be our final position. And just to mention that we are a citizen-driven accountability function, so we need cases to do something. We have an own initiative. We can initiate our own inquiries, but we are overloaded already by the inquiries that we have, so it's very difficult to launch own initiatives. But if you launch complaints on this subject, we'll react on it. So that's my comments on the pure access to information. Coming back to the fraud and corruption, it's true that when handling complaints, and we handled a very large number of complaints, not only related to project impacts, but also related to other aspects of projects, funds, procurement, and other type of banks operation, and we come across of red signs that can raise the issue of fraud. We have the chance that we have one of our officers that is a certified fraud examiner. Myself, I was involved in fraud investigation in a past life. So we are aware of it, and each time that we detect a red flag, we pass it to our fraud investigation office. Okay, that was my comment.
Thank you very much. Thank you. And if we could go to questions now. The lady at the back.
Hello, thank you very much for today's session. I have found it very interesting. My name is Fiona Marshall, and I'm from the Aarhus Convention Secretariat. So it's very nice to hear the name of our convention having been said so many times today. I wanted to speak about one particular provision of our convention, which deals very much with the issues that we're talking about today, which is Article 3, Paragraph 7 of the convention. And Article 3, Paragraph 7 imposes a legally binding obligation on all parties to promote the principles of the Convention in international processes dealing with environmental matters. And this is all international processes that deal with environmental matters, not just purely environmental ones, or ones that are considered the most high-profile ones. And at our recent working group of the parties at the start of this month in Geneva, we had a special session that was looking at what the Aarhus parties are doing to promote their obligations under this provision. And I am very grateful for a number of the people that were here today, including Phyllis Mino and Peter Hobel, and also EBRD, that took part in this session. We had a session that within this thematic session, we had a special focus on what the parties are doing to promote the principles of the Convention in IFI-funded projects. And we had, as I said, the World Bank, EBRD, and EIB taking part in this session. And as a result of their input, the parties committed to identify possible concrete actions that they can take to promote the principles of the Convention in these institutions. And being here today, it has been very interesting to hear the comments that have been made, and I will be taking these comments back to Geneva with me. But I would also invite in the lunch, if you would like to come and talk to me, to talk about possible concrete actions that you think I can take back to Geneva, that I can then share with the parties how they can take these actions in the coming up period to make this real. I'm talking about real things that parties can do, when they're working as board members or in other ways, to make sure that we are pushing the principles of the Convention. And as the Secretariat, we can then share this with our parties and hopefully make some progress in this matter. As I said, we have at the moment, this focus was on the World Bank, EIB and EBRD, because they were the three institutions that took part in this session. However, the obligation of Article 3.7 applies to all international forums that the Aarhus parties are party to. So I am also interested to hear for other IFIs as well. Thank you very much.
Thank you very much. Anyone want to respond? Any other questions on this area? Or, gentleman at the front.
Thank you very much. I just have here a question.
Please identify yourself.
Yes. Oh, my name is Werner Kiene. I'm chairman of the IDB Compliance Review Panel. And I hear with interest this issue of the strength of the commercial interests in some of these negotiations or degrees. This is important because in the international financing world, and I think it's the same in the bilateral international financing, more and more activities are going through the intermediaries, be they banks or something else. And you mentioned here this word legitimate commercial interests, and that has bothered me for some time. We were here some 4 or 5 years ago, and again I heard this, and the question for me is still the same. What are legitimate commercial interests? I see in our operations here our operating colleagues being essentially very timid to stand up against anything that their commercial partners tell them. You cannot say. So the rule, although we have now this disclosure of information or access to information policy, says in all projects we can disclose environmental assessment. So it's what is essentially a document. But what goes then into this document is not very much specified yet. So my question is, and this goes also to the European Ombudsman here, isn't there a need now to define some rules? What is legitimate? Because unless we have a certain standard, our operating colleagues cannot say, I'm not going to sign this, and we cannot judge it. We have in our rules now for the compliance review a specification that we cannot just say something was wrong or badly done. We have to prove it. And we are just starting with our work, but now I understand that there is even hesitation now to let us say this document said this, because there is somewhere a commercial deal that was signed. And there are some religious people in this field who say, I cannot even cite that there was a document signed to this effect. So rules need to be established on what are commercial interests. And I don't know how far we are, and I don't know whether anybody has anything to offer here. Thank you.
Thank you very much. It's a very interesting point. Would you want to take that?
Werner, my usual retort to these kinds of simple questions is to ask the person posing the question whether they wish the answer in 2 or in 4 hours. Let me just say, let me give you a very narrow interpretation of that and a broader one. The very narrow interpretation is, with the usual invocation of the caveat that I'm not a lawyer, I am not aware of any place in Regulation 1049 which governs access to documents in the European Union of any reference to the word legitimate. Therefore, the legal approach, which I'm not necessarily telling you I'm adopting, would be to hide behind that and say, great, but it's not there, The law doesn't say that. But of course, if I were to do that, now I come to the broader answer, I wouldn't be an ombudsman, because the ombudsman would negate himself or herself if they were to kind of stonewall behind the law alone, because all alone I'm arguing that in fact we have to go beyond the law. So that's where it gets to be very, very complicated. In other words, how one defines legitimate enters into what Helen Derbyshire said earlier, and something that concerns us increasingly, into the ethical dimensions of the daily comportment of public administrations that are subject, in fact, to oversight. You obviously are getting into an area of having to determine normative principles, and about 2 months ago, I published a small brochure that some of you may have seen, which is called Public Service Principles for EU Civil Service. And one of these things is precisely to try and heighten the sense of responsibility among civil servants on matters that have to do with ethical behavior. Now, it's not exactly the same thing, but of course what is legitimate is an issue of judgment that it cannot be arbitrary. It has to be based, obviously, on a number of both legal rules and principles of good administration, principles of good administrative behavior. And these vary from context to context. From my perspective as Ombudsman, I value and I put a great deal of weight on precisely these kinds of normative principles of good administrative behavior. But which principles apply to which particular situation would be the 4-hour addition to which I referred to earlier. But this would be my reaction.
Can I add just a simple additional? Our banks are in competition with much bigger banks, and that puts the operating office, the operational office, or the office into a terrible bind. They will tend to agree with whatever nebulous definition of legitimate exists and say, look, I'm not pushing this because there is a big Chinese bank or whatever there. They will just go with it. So we need something, don't call it illegitimate, but somewhere principles, and I don't see them yet.
My response is, this is partly covers that. This partly covers that. That is for EU civil servants. Okay, it's not necessarily beyond that. Secondly, I can only respond, and I'm perfectly happy to respond, to a concrete case that comes before me, will then involve my legal services advising me, so I can then come up with a kind of political decision or where I wish the institution to stand on a particular issue. This having been said, Werner, it's also the case that I reluctantly, occasionally reach the conclusion to say, these are the principles that the Ombudsman espouses and applies to the EU civil service, while fully recognizing that there might be institutions beyond my reach which say, that's fine, but I have different principles. And you want to avoid, of course, the famous Groucho Marx statement that these are my principles, but if you don't like them, have others. And this is not what I'm telling you. Thank you.
Thank you. I know.
I just wanted to add, it is in the law, because it is in the Aarhus Convention, but the Aarhus Convention only applies to environmental information.
1049.
So, but not in 1049. And that's also why 1049 does not comply either with the Aarhus Convention. But that's another issue. So if 1049 complied with the Aarhus Convention, it would be in EU law, and then we could also have case law from the European courts on what is legitimate economic interests. And I agree with you that it's one of the exceptions that is used the most by, not only by the EIB, by all the other European institutions. For example, the Commission in the Porsche case that was brought to the Ombudsman by Friends of the Earth Europe, and that then Client Earth helped them with after the Ombudsman adopted his decision because the Commission was not moving. It took I think more than a year for the Commission to disclose letters. A year and a half to disclose letters exchanged between the ex-commissioner on transport and Porsche, the company Porsche, just because it was said that they had dinner together when the CO2 emission approach was adopted by the Commission at the time. And so, and it was protected under the exception on the protection of commercial interest. So once again, I think that what's really important is that the European institutions should not use this exception just to protect the reputation and the image of a company. We can understand that commercial or industrial secrets are protected, but not the reputation or not their lobbying activities. Lobbying activities should be more transparent as well.
And Gina?
Just a quick comment, slightly off topic, but related in this sense, and that is from the practitioner's perspective. I think it's the responsibility of the accountability mechanisms to push the boundaries of their mandates as far as possible without contravening any law or regulation or policy, but to look for ways of giving voice to concerns that are raised by the communities. This debate that we're having here is particularly legal in nature, and I understand I'm a lawyer, and that's fine, and it needs to be had. But I think we also need to remember that where a mandate says social and environmental concerns, we need to be really smart about how we meet the needs of the communities that are being raised. And it brings me back to another comment that was mentioned earlier, and just the way we're structured here. We don't see civil society as adversaries. We welcome constructive criticism, and I think we need to work as allies. The accountability mechanisms cannot deliver everything. They're not going to be able to address all the concerns raised by impacted communities, but they may well be able to deliver on some. And I think that civil society need to be clever about how they use us and how they work with us to meet the needs of communities that are raised.
Helen?
Thank you, Alex. I just wanted to comment on this particular question about the commercial confidentiality and what is it and how do we define it and how this exception should be interpreted. And maybe this is an example where we need more debate, but we also need more information because we have, as I mentioned, 93 countries around the world with access to information laws. And I don't know, I haven't checked, but I don't think there's one that does not have this exception. Around Europe, we have ombudsmen, information commissioners taking decisions on balancing access to information against commercial interests on a sort of weekly, if not daily basis. So there's an enormous, and then there are court decisions on it. There's an enormous amount of information and debate and thinking that has gone into this already. We have, but in terms of whether we have the word legitimate or not, what we do have is we have this right of access to information under the international treaties, in the EU treaties, and that is a right which can only be limited if there is a really significant interest, and that interest has to be balanced against the public's interest in knowing. In the words of the European Convention on Human Rights, the exception has to be necessary in a democratic society. Now, the mere fact that a bank that's operating with public funds, particularly, is in competition with a Chinese bank, I would say is not a sufficient justification in a democratic society for excluding access to all the information which it holds. One has to look at it on a specific case-by-case basis, and the actual harm that would be caused to a particular process in that very specific case, and that may be time-limited to deny access as well. So perhaps what we need to do is come back to this point and explore it more in detail, because I think a lot of thinking's already gone into this, which would enable us to make faster and better decisions about what we release and what we don't release in the public interest.
And I know Peter's been having his hand up.
I have two questions. One, I believe Mrs. Barbieri was referring to Agri-VF Fund case in Uganda when you were talking about the land grabbing. Last year, this case was presented to the EIB Board of Directors, and President Maystadt, which is co-founder of the project, and President Maystadt committed that he will start an investigation. So the question is whether the EIB is actually investigating the case as well, because we didn't find the information. And then the second more general question, there are more and more cases where the institutions are on the same project, the complaints are raised. And my question is actually where you identify the main problems in the kind of parallel investigations of the cases, and whether you are able to identify, whether you are able to go after the higher standards if the two institutions do have a different standards in the term of the access to the information. Thank you.
Okay, I'll let Felizmino obviously address the EIB approach and investigation, but just on the latter half of the question, before I do that, I made a glaring omission in not introducing my colleague Emily Horgan, the specialist of communications from our office, who is here with me today, and I'm going to blame it on the very strong Belgian beer we found last night. But my colleague is over there, and I'm going to encourage you all to engage with Emily. I really want to hear your ideas about how we make ourselves known to communities across the world, but we'll get there, because I hope we get to ask you questions at some point. But coming, Peter, to your comment, we've just spent 3 days together as the accountability mechanisms talking about a number of issues, and one of them is cooperation when we are engaged in co-finance projects. Now, there's some differing views around how that can work. So I'm going to give you my view, actually, on the issue, and not even necessarily the CEO's view. My view on this is as follows. I think communities have the right to forum shop, and I think they have the right to utilize whatever they can to have their needs addressed. If we receive complaints that touch on a number of accountability mechanisms and the communities say to us as the CAO, we really want to try dispute resolution, and the communities are comfortable that we manage that process, we will welcome engaging with the other accountability mechanisms on how that's going to work. And we're actually doing that currently in Bujagali on one of the aspects of the complaint that involves both the EIB and the CAO. It's pointless running two parallel negotiation processes between the same parties about the same issues. And so we look for collaboration where it's possible. But I don't think we should be looking to collaborate to the extent that it negatively impacts on the maximum outcomes that communities can achieve. I mean, that's really the principle I think we just need to remember.
Yes, on the NFC case. We may investigate a case when we receive a complaint on own initiative, on when requested by the President or the Management Committee. In particular case, after the board meeting, President Maestad by that time officially requested us to launch an investigation. 1 week after, he asked us officially to put it on hold, waiting for the process ongoing by the company themselves, the dialogue between Oxfam and the government of Uganda. The situation of this investigation is still on hold, because for us is a request by the President and by the Management Committee. We have no interference. They ask us to put it on hold. It's on hold. We have been, by that time, in the same board meeting, we have been contacted by Oxfam that was intending to launch also a request for compliance review. But as you know, it's public from the press, Oxfam has been under pressure from the government of Uganda not to invoke the case publicly, so we have not received any complaint from the NGO world or from the people on the ground. What we do, we are following a little bit from distance the process, the current process ongoing with CAO, and see what will be the outcome and see if there is an opportunity for us to get involved. But for the moment, we are not interfering. On the issue of collaboration, I'll present my personal view that is not, maybe is not shared by all the AIMs. I think it's in the interest of everybody, on our own interests as IAMs, on the interests of the institutions, and on the interests of communities and affected people, or international NGOs, that we collaborate as much as we can and we harmonize as much as we can. Before the institutions, because it's a resource optimization, and within the institutions, all of us, we are fighting for resource allocation. It's better for the mechanisms because if we are two or more on a case, we represent much more capital invested on a project, so we have more leverage. and it's better for the people because they don't deal only at different times, but they deal with all of us together. Having said that, we need to go examine case-by-case basis to see which option is the best.
Great. Any other questions? The lady at the back.
Hello, I'm Rosemary Bubutu from African Geopolitics. I have a question for Mr. Ombudsman. I would like to know whether EU bodies operating in non-EU states have the same obligations with regards to right to information and access to documents as EU citizens, or is there a double standard there?
If I understand your question correctly, you're asking whether EU bodies
operating outside the EU have the same obligation.
The answer is absolutely not. In other words, if you're an EU body, you're subject to EU regulations wherever in the world you are. And I have had cases where I've had to deal with complaints raised by entities outside the Union, but we talk about EU bodies, okay? This is what, no, the answer is no double standard, one standard. Okay. But this gives me the occasion to say something else in addition. The collaboration we have with the EIB is a classic example of how we try to get around another problem, which is, do third parties outside the Union involved or affected by EU projects have rights?
Yes.
And in the case of our understanding with the EIB was precisely at their request, they set up, and in order to be able to allow me to be able to review it, because I would not be able to review it if it's outside the EU borders, they set up their own internal complaints mechanism, which is headed by Mr. Alcarpe, which therefore gives me the opportunity to review what the EIB is doing in a third country, but it's now become an EU matter, and therefore it is within my own mandate to do it. Okay. The third way of doing it is if I consider that the matter concerns a potential breach of a fundamental right or of a major issue, I do have the right to launch an own initiative, an inquiry on my own initiative, okay? But I would have to involve, obviously, an EU institution, okay? I cannot go and say what happens in Uganda. We have a Ugandan citizen. The Ombudsman, for humanitarian reasons, needs to investigate that because, for very legitimate reasons, the Ugandan Ombudsman or authorities would take exception to what they would consider a neo-colonial approach. Thank you.
The gentleman there has been holding his hand up longer.
I am Octavian Șerban. I am researcher at Knowledge Management Institute, Romania. I am teaching associate at Academy of Economic Studies. We are talking here, first of all, it's very important, this kind of knowledge platform you create here. Is the second time this year I have the opportunity to participate at this kind of event organized by the Ombudsman. First previous event, it was in the same location with the participation of President Barroso and President Schulz, if you remember. We are talking here about the complaints against action. For example, if a development bank is put the money on the project which is harming a population of a country, me as a citizen, I have the right to complain against that project or procedure or something like that. But it's another side of the coin. As Helen said on the first presentation, about the efficiency of the spending of structural funds. In Romania, we have a lot of money. We have structural funds. We have money from development banks, from World Bank, and so on. During this financial framework, we have from European funds, we have 35 billion euros. Totally, from World Bank and so on, we have almost 70 billion euros. That means twice our national budget, annual national budget. but we are not able to absorb this money. These money are for something. There are some clear objectives. Pollution, increase the living standard, the skills of the people, and so on. It depends on each program they are addressing. To whom we have to complain about this inactivity? Because me as a researcher or part of academia, we propose to our government a lot of solutions. But our government, whatever, we have several years, several governments, of course, but we are the same. The population, we have some needs, and the European Commission is giving us the money. Me as a citizen, I pay the tax to my budget. My country is paying the contribution to European Commission. Now European Commission is coming in my country and cut all the money because are not efficient spending. We have now, today, the delegation of IMF in our country. They,
I understand.
Yeah.
I understand.
You see.
I understand you clearly.
Thank you very much.
So how can you raise a complaint when something doesn't happen?
Inaction could be maladministration. There's no question about that. But we have to. Thank you. This is a very good question for a reason other than the one that you intended, and let me just say that. This is a good opportunity also to explain to civil society organizations and to participants, what we can, what we cannot do. Okay. Now, what you're referring to, I'll answer it, and there's always the possibility of making a mistake because I don't have all the facts before me. Okay. To come to the European Ombudsman, you have to fulfill two conditions. You have to have a breach of EU law or EU rule by an EU institution. So if the European Commission is directly funding something, directly, not through your ministry, in that case, if you believe that the European Commission is breaching EU law, then you can go either to the Ombudsman or you can kind of move and try and contest it. If, on the other hand, the monies through the structural funds, as you said, are coming in from the European Union, but they are being, in fact, processed through the national institutions, Ministry of Transport, Ministry of Infrastructure, etc., and all that, then by definition, this very difficult concept on which the European Union is based, called subsidiarity, kicks in, okay, which is that, you try and deal with problems as close to the ground as possible. So if there's a breach of EU law at the Romanian level, you have to go either to the Romanian Ombudsman or to whatever Romanian institution is in fact empowered to deal with potential, breaches and allegations. It is automatically not something that I can take because it's outside my mandate. So this is the answer to that question. I fully understand that. The problem, you're not the only country that is, in fact, is proving to be whose administrative structures prove incapable of, in fact, using the monies that are being given to them. I can think of another country that I will not mention. But I would say to you that this is clearly something that you have to, as a citizen, you have to identify whether it is at the national level, at the European level, and if it's at the European level, you come to us. The final thing is the easy solution, and that's where the European Ombudsman can help you. Okay? You lose nothing by writing me a letter and asking me, and I'm going to answer you formally, but the more concrete you are, the better I'll be able to help you. If you tell me the EU institutions are not, I cannot help you, but if you specifically ask me about a particular issue, my colleagues will give you an answer. In fact, my Romanian legal officer is present in this room, and she's, I'm sure, listening to you with great interest, and would be happy to also engage with you, during the lunch, if she's around.
Well, there we go. Isabel?
This is a very interesting question because I think that more and more we, the accountability mechanisms, will have to get involved in some of the other policies, meaning the policies that have to deal with omissions of the institutional financial institution, not only with actions. Actually, our policy already mandates actions or omissions. Of course, more focus on compliance of environmental and social policies. But also, I think this is common for the World Bank and for the IDB starting in 2013. We are responsible for implementation policies, supervision policies, conditions of the loan policies. So it's not only that you can come and complain about a community not being heard, but maybe it will be, that's why I think it's a two-way street. It will be the responsibility of civil society, and of course we have to expect that NGOs will play a greater role on this, to be vigilant on this other dimension. Now, your example has to do with two things. One is the absorptive capacity of governments that I don't know whether we will ever get to there. But the banks, having in their charter a provision that rarely they remember, they are a last resort financial institutions. They are not commercial institutions. They are development institutions. Therefore, their main objective is to promote, and I'm talking about the two banks I know the most, of course, the World Bank and the Inter-American Development Bank, is to promote development, fight against poverty and all of that. So your question encompasses a series of policies that go beyond environmental and social policies, and I think we'll get there rather soon. There are two things, just in closing, thank you, Alex, for this, that I would like to emphasize when it comes to harmonizing our procedures and harmonizing our work. First is the tremendous envy I have for the work that Transparency International and our anti-corruption colleagues have done. So they achieved this level of harmonization, which is actually proven to be very effective. We hope to get there, and we hope that as Transparency International helped so much the banks and the institutions to achieve that level of harmonization, NGOs will help us in accountability matters to get our act together and be more harmonized. There are two stages where we really need to be harmonized, in my modest opinion. One is accessibility. It cannot be that it's easier to access one bank than the other, and we have mechanisms with different heights of the bar, and I think we have to think of accessibility as a first criteria for harmonization. But the other one is related to triggers. You heard Felizmino and others saying they have the ability, and this is also true for the CEO, to initiate investigations, to launch investigations or reviews. There are other mechanisms that we don't have that ability, and therefore we depend on not only the demand-driven nature, but also we depend on the ways communities or NGOs will find to actually get to us when probably our accessibility bar is still very high. So I think as a homework for all of us would be to work much more in trying and harmonize our accessibility criterion and the triggers, how we can have at least those two things harmonized so NGOs do not need to spend time and overstretch themselves, and communities do not need to overstretch themselves and shop around. They will have more or less a common standard to attend to. Thank you.
I'm afraid we're probably have run out of time. We've got lunch at 1 o'clock, but I will ask Mr. Diamandouros to wrap up today, and which has been a very lively debate, an excellent example of everyone exercising their right to know. And I would thank the European Ombudsman and Milos for putting on the event and for the incredibly good attendance here.
Thank you, Alex, and thank you also for so adroitly taking care of all of this, the technical way of leading and moderating and all that. We appreciate your offer and your willingness to help us. Let me just make a few concluding remarks. I know that intellectual nourishment is important, but so is, in fact, material nourishment, and you all wish to go on to the lunch. But I'll make a few quick comments. Let me just say, apropos, picked up from a number of areas. I think you mentioned very clearly about the importance of procurement in terms of that. So I want you to know that this is an area where the Ombudsman is very active, and we have very good and strong engagement with the European Union institutions in trying to ensure transparency in the procurement area. And we're being both reactive and proactive. Reactive in receiving complaints, proactive by myself and my colleagues going out and engaging directly with the civil servants involved in procurement. So last year I had a session with the entire Directorate General for logistics, infrastructure, and their procurement area of the European Parliament. And I talked with all 70 of them, precisely on what their obligations are, according to the Ombudsman and the demands of good administrative practice. So we do both precisely in order to both react but also to educate and to be able to promote what we call a culture of service to citizens. The second point is, at one point or another, the discussion of of Zambia being outside the Union came up, and I partly answered that question about what we do with complaints or issues that arise that are beyond the frontiers of the Union. It is clearly something that we're very aware of, and we also have a similar kind of a problem. I'll mention it also. That again points to the difference between law and good administration. We very often have a problem with the European Commission where we have subcontractors to particular contracts coming to us and saying, I haven't been paid. And the Commission says, that entity does not exist in my contract. I recognize a contractor. I have a contract with a contractor. I don't know anything about a subcontractor. Sorry, Ombudsman, there's nothing that I can do about it. And what we're doing is we're making great efforts, and the Commission has shown itself to be cooperative, to also appreciate the extent to which it needs to care for and to be aware of the kinds of problems that may arise if a ill-intentioned, incompetent, obstreperous contractor turns out to in fact be acting in ways that are injurious to a subcontractor, even though there is no legal contract. So we're trying to negotiate areas of good administrative practice with the Commission to be able to in fact address these issues. Third point, apropos of something that Helen said about public interest. In Regulation 1049, and I won't take you very far there, there is a particular provision that says if there is overriding public interest, then you must release. The problem with that is, and this is one of the great frustrations with the Ombudsman, is that the institutions systematically avoid, like the plague, ever invoking that particular issue because there is no jurisprudence on this issue. The courts haven't spoken about that, and for all practical purposes, the overriding public interest, which would be the exception to the exception that would allow you to release, is a dead letter. And we are, in fact, we've tried unsuccessfully to elicit responses that would get around this problem, but it is clearly an area where, in fact, a lacuna still exists. My final comments will be offered to you in earnest, but also will give you a chance to be able to see the Ombudsman in operation, if I can say that. I already referred to, and I will not belabor the point, on the importance of ethics for the Ombudsman. It's not only this particular publication, but in fact the issue of ethics is now becoming a heightened concern in the EU institutions. Certainly the Commission and the Parliament is issuing guidelines for ethics, both for its staff and for its members. So the Ombudsman is trying to push the frontiers of that. I'll be travelling to New Zealand later in the year for the World Congress of Ombudsmen, and what I will be addressing will be precisely issues of ethics in this area. So this is something that I want to reassure the members of civil society present that it is now very high up on the Ombudsman's agenda. The second point on, and I hope Isabel will forgive me for that one, it's not an issue of political correctness. I can give it to you on high authority coming from Sweden where the institution originated, that the word ombudsman is gender neutral. There are lots of lady ombudsmen in Sweden and in Norway and in Denmark. So all the ombudsman can do is try to persuade. Of course, he can never impose his use, so I would make a plea for the use of the word as such. But, of course, I will defer to individual preferences. And certainly in the United States, this has certainly been the trend towards using ombudsperson, ombudswoman. The States has also invented something which does not quite go well with my ear, which is turning the term into a verb, you ombuds. You know, I find that stretching credulity. You haven't said that, so I'm just... Okay. My last point is, again, seeing the ombudsman in operation. The French have a very nice expression called déformation professionnelle, which you could translate roughly either as professional deformity or professional perversion. And the ombudsman's déformation professionnelle is to try to be fair at all times. So I wish to stand corrected about something that I said earlier, apropos of my intervention following Peter's comments. He volunteered the fact that the information he gave apropos of the EBRD was a partial excerpt of a much longer letter, thereby correcting the impression that I had, and therefore I'd like to stand corrected for having, in fact, chastised the EBRD in public for, in fact, what I thought was poor administration. If you have 3 letters and long letters, then you've actually met prima facie the requirements of good administration. So therefore, the Ombudsman has to be critical of himself, and he's done that, and I want to publicly make that statement. This having been said, I want to thank the panelists, I want to thank Alex, but I want to thank particularly both the IAMs who took a long ride from Luxembourg last night in a bus to come here and be here in the morning. It has been a very important meeting for us in Luxembourg as well. But above all, of course, I wish to thank the members of the civil society who are coming to these meetings and giving these meetings meaning increasingly. These are very important events for the Ombudsman, and we wish to go forward with it, but we cannot go forward unless we have your participation. So therefore, we thank you, and we hope that you will continue to support us. Thank you very much. One last technical thing. There is a phone on the floor. It could be yours. All right, good enough. Thank you.
Thank you very much.